The issue raised on the motions before me are whether the failure of the plaintiff to serve a notice of claim that was sworn to is fatal to the action commenced against the Port Authority of New York and New Jersey. On October 1st, 1999, plaintiff's counsel wrote a letter to the authority asserting a claim for unpaid services rendered of $27,581.18, as well as a claim for a possible exposure of having to pay an additional $15,000 in insurance premiums. By letter dated October 22, 1999, the authority asserted that plaintiff had breached the contract with the authority and consequently denied the claim. On January 21, 2000, the summons and complaint in this action were filed with the county clerk, in which plaintiff seeks $34,581.18 in past damages plus $300,000 in loss of profits. By answer dated March 27, 2000, the authority asserted as affirmative defenses that the court lacks subject matter jurisdiction and that plaintiff failed to comply with the jurisdictional prerequisites sustained in defendant's statute. Before me are plaintiff's motion to strike the aforesaid affirmative defenses and the authority's cross motion to dismiss the action solely on the ground that the October 1st, 1999 letter sent by plaintiff's counsel failed to satisfy the notice of claim requirement that it is unverified. The consent of the authority to be sued is conditioned on a notice of claim being served by or on behalf of the plaintiff at least 60 days before each suit is commenced, which must be sworn to by or on behalf of the claimant. With respect to similar notice of claim provisions in General Municipal Law, Section 50E, which requires that the notice be sworn to, and Education Law, Section 3813, which require an allegation in a complaint that a verified notice was served, the Second Department has repeatedly held that a lack of verification of the notice of claim may be excused or corrected. However, the recent decision of the First Department in City of New York versus the Port Authority appears to have concluded that the lack of verification in a case against the authority deprives the court of subject matter jurisdiction. The lower court decision in that case shows that an unverified notice of claim was served by the City of New York on the authority on October 26, 1999. On November 15, 1999, the authority informed the city that the notice was defective because it was unsworn. On December 2, 1999, the city served a verified notice of claim that otherwise was identical to that served on October 26th. On December 30th, 1999, the city served a summons and complaint upon the authority, and on January 5th, 2000, the authority advised the city that the action was defective as having been commenced prematurely, as served less than 60 days after the service of the unverified notice of claim. While the city argued that it had substantially complied with Section 7107, the lower court dismissed the action, concluding that since the notice requirement is a jurisdictional requirement, it must be strictly construed and cannot be waived. The appellate division affirmed the dismissal, holding that the city failed to comply with the notice of claim requirements and that defects in a notice of claim served upon a state agency may not be officially waived where, as here, there is no statutory authority for such waiver. Although the appellate division did not discuss any of the foregoing Second Department cases, there is clearly a difference between the power of a court in cases decided under General Municipal Law, Section 50E, compared to those decided under Section 7108, as the former contains Subdivision 6, which provides that a mistake or defect made in good faith in the notice of claim required to be served by this section, not pertaining to the manner or time of service thereof, may be corrected or disregarded as the case may be in the discretion of the court. Was it 120?
120.
Turned out at 30s.